Hi, hello everybody. This is Uma from Success Law Classes. Today we are going to discuss with regard to Delhi High Court case law, where the Delhi High Court has reduced maintenance awarded to the wife, stating that spouse having earning capacity choosing to be unemployed must not saddle the other party with responsibility. The cause title of this case law is Chetram versus Karishma Saini. Neutral citation is 2023, Delhi High Court 8322. The date of decision is 21st November 2023. In this case, the Delhi High Court has held that a spouse having the capacity to earn, choosing to be unemployed, should not be allowed to burden the other party with one-sided responsibility of said that the provisions of maintenance under the Hindu Marriage Act 1955 is gender neutral. An appeal was filed against the order passed by the Family Court South Saket, New Delhi, by which the husband was directed to pay rupees 30,000 per month as maintenance of Justice V. Kameshwar Rao and Justice Anup Kumar said that the spouse having a reasonable capacity of earning but who chooses to remain unemployed and idle without sufficient explanation or indicating sincere efforts to gain employment should not be permitted to saddle the other party with one-sided responsibility of meeting out the expenses. The equivalence does not have to be with mathematical precision but with the objective to provide relief to the spouse by way of maintenance penalty and the litigation expenses, who is unable to maintain and support during the pendency of proceedings, and to ensure that party should not suffer due to paucity of source of income. The provision is gender neutral, and the provisions of section 24 and 25 of Hindu Marriage Act provide for the rights, liabilities and obligations arising from marriage between the parties under Hindu Marriage Act. Facts of the case here is the parties were married on 19th November 2018 and ceremonies. Further, wife returned to her parental home on 7th July 2020, owing to differences between the parties. The wife then preferred a complaint under Section 12 of the Protection of Women from Domestic Violence Act 2005 against the husband and his family members on 27th January 2021, wherein the husband was directed to pay rupees 21,000 per month to the wife as maintenance via an order dated 12th December 2022. The husband also preferred the divorce petition against wife before the family court, wherein an order was passed under Section 24 of the Hindu Marriage Act, directing the husband to pay rupees 30,000 per month towards maintenance penalty to the wife, along with litigation expenses of rupees 51,000. Hence, the matter was appealed before this High Court. The High Court, in the above context of the case, noted that as per the copy of payslip for the month of May 2022 filed on record, out of gross salary of rupees 1,04,276, deduction of rupees 25,000 is reflected against court recovery, 7 against society recovery, apart from other statutory deductions. Thus, the net salary received by the appellant after deductions and recoveries is 56,492. The reasons for granting higher maintenance penalty of rupees 30,000 per month when compared to maintenance of rupees 21,000 per month awarded in the proceedings under Protection of Women from Domestic Violence Act initiated by the respondent have not come up in the impound order. Even no substantial change of circumstances after passing of order in proceedings under Protection of Women from Domestic Violence Act has been brought to our notice. Court added that while considering the quantum of maintenance, the liability along with his duties towards other family members cannot be ignored. It said that though the wife claims to have no independent source of income but has reasonable educational background, being a graduate from Delhi University, she appears to have voluntarily undertaken social work as claimed, despite there being no impediment for undertaking a meaningful employment. We are of the considered that maintenance pendently at the rate of rupees 21,000 per month to the respondent as paid in the proceedings under Protection of Women from Domestic Violence Act from the date of filing of the petition before the learned family court till its disposal would be reasonable. It was observed by the court. Accordingly, the Delhi High Court disposed of the appeal, modified the order, and reduced the amount of maintenance with progressive increase with time considering inflation. Thank you all. Please subscribe my channel, like and share this video, and comment if you have any doubts.